Good afternoon, everyone, and welcome to the Alternative Dispute Resolution Certification Working Group. I'd like to remind you that the meeting is being recorded. Angela, would you please take the roll?
Yes. Armstrong, Coulter, Curtis,
Here.
Dinkin, Dubo,
Here.
Ellis,
Here.
Dr. Getz.
Dr. Getz, we didn't hear you.
Did he say yes?
We can't hear him, but I'll note him for the record. Thank you.
Okay, thank you. Higuchi, Hodgson, Jones,
Here.
Kelly,
Here.
Kopaken,
Here.
Cruz, Lowe,
Here.
Judge Lucky,
Here.
Pilevsky,
Here.
Judge Pichon,
Here.
Robertson,
Here.
Tuckman, Welch,
Here.
and Yamshawn.
Here.
Thank you.
And Chair, sorry to interrupt already, but I'll just note that I believe Tuckman is here as well as Coulter.
Yes, thank you.
Thank you.
This is Eric Tuckman here.
Thank you. Next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
Yes, for those participating who would like to give a public comment, you can use the raise hand function at this time, and you will be called on the order that your hands are raised. If you're calling in by the phone, you can virtually raise your hand by pressing star and number 9. Each speaker will have 3 minutes with a 30-second verbal warning. We do have one person who signed up in advance, and I see that he's here, Cordell. I will enable your mic and you can start your public comment.
There we go. And I'm not able to have video, I think. All right. Well, thank you so much for having my comment. I did submit written comments. I wasn't sure if those would get disseminated to everyone before the meeting, so I'm sure you'll all have a chance to read those if you haven't yet. But basically, my question is, will there be an opportunity to develop subject matter or specialty certifications, specifically within the field of mediation, beyond just a general certification? In my written comments, I also provided kind of an anecdote, or from my experience, I actually work with the state of California, Department of Social Services. We do, I'm with Consortium for Children. We do mediation within the child welfare system, which is its own kind of niche, doing kind of adoption competent mediation, which is not, I don't think, as well known to folks, but I could see really there being a benefit in having subject matter mediators, and that being a part of the certification process. And again, in my written comments, I kind of share the importance and how impactful it can be having knowledge of the child welfare system to our mediators versus those that are not. And I'm sure, having subject matter expertise is just as impactful to those that are mediating in other circumstances like divorce or contracts or, business mediation. So just kind of want to advocate for that, as well as making sure there is a differentiation between the different ADR fields. ADR is a big term really that encompasses a lot of different things, and really want to support that differentiation between all the different fields, as well as, of course, differentiation from the practice of law and all that kind of stuff. So that's really what my comments entail. I'll encourage you to read what I sent, and I'm happy to answer any other questions or provide any other support. But I will cede my time there. Thank you so much.
Thank you, Mr. Wesselink. Ms. Doherty or Mr. Weiner, do you have anything to offer in response?
No, not at this time. We typically don't respond to comment. I think last meeting there was an exception to that because there was a kind of question directed to staff at that time.
Okay, thank you. And Ms. Marlott, are there any other members of the public who wish to speak?
Yes, there's one more. Jeff Bloomfield, your mic has been enabled.
Can you hear me?
Yes.
Okay, good. I submitted some written comments. I don't know if they've been distributed, but I can go over them briefly. I have 3 concerns. One is what will be the cost of certification. I'm especially concerned about that because I'm a volunteer mediator in the Alameda County Small Claims Court. And I'd say a significant percentage of us are retired living on fixed income. And I'm aware that the proposed law says that the cost of certification will be paid for through California bar fees. And what I would really want to see happen, both for retired mediators, but also to bring mediators in from lower income communities, I'd like to see some provisions so that the fees can either be vastly reduced, whatever they may be, or waived in, clear-cut cases. My next point concerns complaints against, I know that the bar wants to set up a complaint process along with the certification process. And right now, the ADR and the Alameda County Court already has a process in place that has been in place for over 20 years. And it comes under California Court Rule 3.869 and Local Court Rule 3.750. And at least for volunteer mediators, it doesn't make sense to me that there be one or more parallel processes, since for volunteer mediators, the court is already taking care of this. And, taking care of complaints, I don't know how burdened the bar will become with complaints. One hopes not. Finally,
30
I'm
seconds.
concerned about this is quick, the confidentiality of Alameda County Court volunteer mediators, because if there's an outside complaint process, right now, complainants are able to speak freely in the mediation room, knowing that, as they paraphrasing Las Vegas, nothing inside the mediation, everything that happens inside the mediation room stays there and nothing else leaves it. So I'm concerned about an outside complaint process compromising the confidentiality that we have now.
Thank you, Mr.
That's
Bloomfield.
my comment.
Thank you very much. Ms. Marlott, are there any other members of the public who wish to speak?
If you'd like to give a public comment, please use the raise hand function at this time. And I don't see any more raised hands.
Okay, thank you, Ms. Marlott. All right, we'll move now to approval of the minutes from the last meeting. And first, we'll take approval of the March 19, 2025 open session minutes.
Madam Chair, is this an appropriate time to talk about public comment?
Oh, yes, it is.
I think that's our first item on the agenda. Oh,
Go ahead.
but I'll defer to the chair of the staff if there's some better time to talk about it than now.
We typically, so items that are of public comment are specifically supposed to be tied to items on the agenda. And so we would typically take them up at the time we are discussing that particular agenda item.
Although we had a written public comment that was from the Monterey College of Law that refers to what we approved last time, that, just to paraphrase, says they would like us not to set up 2 conflicting parallel complaint proceedings. And that's just what Mr. Bloomfield is talking about. So you tell me when it's the appropriate time to discuss something we already allegedly decided.
Sure. Well, that topic, that this is the challenge. That topic is not actually agendized for today. It's not technically something that was agendized for discussion as a public comment item. So we could certainly add that to a future meeting. But typically items are supposed to be, public comment is supposed to be made for items that are agendized as topics of discussion for the working group.
I'll defer to the wisdom of the staff, but I'd certainly like to, I don't know if our subgroup's going to meet again. I haven't heard yes or no, but if so, I'd like to refer that back to our subgroup. I think it's an important topic. That's all.
Sure. And discussion of subgroups is something that is agendized, so we could talk about it in that context at that time.
Okay, thank you. So there's a brief staff report associated with this. So Ms. Doherty, would you please present on the March 19, 2025 open session minutes?
Sure, thank you. I will be very brief. This is just kind of a reminder for everyone, just in case you don't recall. So at our April 23rd meeting, there was a motion to revise the March 19th minutes to reflect a straw poll that was taken during the March 19th meeting. Those minutes have been modified to reflect the straw poll vote. And so the minutes as revised are presented for a possible vote and approval today.
Thank you, Ms. Doherty. Are there any corrections or modifications? May I have a motion and a second?
So moved.
Mr. Kelly, and a second? Mr. Polewski. And Angela, would you please call the roll?
Yes. Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois. Paul, are you there?
You're muted, Paul.
Yes.
Thank you. Ellis,
Yes.
Dr. Getz, Higuchi is absent. Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent. Lowe,
Yes.
Judge Lucky,
Yes.
Polewski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes,
The motion carries with the majority.
thank you. Next, we'll move to the approval of the April 23, 2025 open session minutes. Are there any corrections or modifications to the open session minutes? Hearing none, may I have a motion and a second?
Lucky, I'll move.
Second.
All right, so Judge Lucky made the motion. Mr. Kelly seconded the motion. Angela or Ms. Marlaud, would you please call the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois, Ellis,
Yes.
Dr. Getz. Dr. Getz, you're on mute if you want to vote.
I don't think he is on mute, but we're having a hard time hearing you.
How about now?
Great.
Perfect.
Yes.
Thank you. Higuchi is absent. Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken,
Yes.
Cruz is absent. Lowe,
Yes.
Judge Lucky,
Yes.
Polewski,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshawn,
Yes.
Judge Pichon.
Yes,
The motion carries with the majority.
thank you, Ms. Marlaud. Next would be my report as the chair. However, I don't have anything to report on. So we'll move to the staff report. Ms. Doherty, I believe that you have a very important announcement to make.
I do. Thank you, Chair. I will be brief because I'm going to ask that Mia Ellis, who has joined us today, introduce herself. For those of you who have not seen Mia on a few communications that went out, Mia is going to be ultimately, although not today, taking over as the staff lead for the ADR working group. As you may or may not be aware, I've had a bit of a change in responsibilities. And so she will be the lead on this project. I will just say, I'll take a moment to say that I have greatly enjoyed working on this project. I plan to continue to work on this project, but not in the same capacity that I have been doing. So not perhaps at the subgroup meetings that we've had that I've had the benefit of attending, but I think that ultimately the division of regulation within which Mia works is going to be taking on this program once it is implemented. And I think that she is very well positioned to do that. So I'll let Mia actually introduce herself, but I'm really looking forward to her joining this project.
Thank you. Thank you, Erica. Good afternoon, everyone. Again, I'm Mia Ellis. I'm currently, for the last 2 years, has been serving as Deputy Special Counsel in the Division of Regulation, which encompasses the licensee, record, and compliance part of the bar, as well as the Office of Professional Competence. I have, prior to being in the Division of Regulation, I was in the Office of Chief Trial Counsel for several years. Very happy to be here and nice to meet all of you.
Welcome, Ms. Ellis, and a very warm welcome. And I look forward to working with you. Thank you.
And Chair, I have nothing else to speak to in the staff report. Thank you.
Right. Thank you, Ms. Doherty. So next on the agenda is the business, and that's item 2.1. We do have a presentation on occupational registration, licensing, and certification. And I should ask first, is Professor Kleiner present?
He is.
Okay.
Yes.
And I've asked Vice Chair, Dr. Getz, to introduce our guest speaker, who is Professor Kleiner. Dr. Getz.
Judge Pastan. After our last meeting, the leadership discussed the various viewpoints expressed. It was clear to us that the group could use more background in occupational governance and regulation. As a result, we reached out to one of the nation's leading experts who delightfully agreed to join us today. We are honored to welcome Professor Morris M. Kleiner, widely recognized as the nation's leading expert on occupational licensing. Professor Kleiner is a professor at the University of Minnesota's Humphrey School of Public Affairs and a research associate at the National Bureau of Economic Research. His work focuses on how labor market institutions affect productivity and employment, with particular expertise in occupational licensing regulations. His research has been published in premier academic journals and featured in major media outlets, including the New York Times, the Wall Street Journal, and the Washington Post. Professor Kleiner's distinguished career has earned him significant recognition, including the 2018 Lifetime Achievement Award from the Labor and Employment Relations Association, the 2024 Economics Career Achievement Alumni Award from the University of Illinois, and most recently, selection as a Yagillian, I'm sure I'm not pronouncing that correct, visiting fellow at the Hoover Institution for 2025. Professor Kleiner will present his insights on occupational regulation, which includes licensing, but also the less restrictive certification with which we are working with as a group, and has agreed to answer your questions following his remarks. Please join me in giving a warm welcome to Professor Morris Kleiner, who will share his insights now. Thank you, Professor Kleiner.
Well, thank you. Thank you very much. And I'm delighted to be here. And hopefully some of my work will be of use and service to the deliberations of the group. Wanted to know if I can share my slides with you. If I'm a co-host, I think I can.
Please do so.
Can you see my slides?
Not yet. Angela, do you want to be prepared to? Oh, there we go. We do see them. They're not in presentation mode yet.
Okay. Are they now?
They aren't, but I think everyone can see them quite well, so I'm not,
Let
oh,
me start again.
okay.
Can you see them now in presentation mode or?
They're in the same format, but they're
Okay.
quite, at least on my screen, they're quite large. So, oh, I think you're okay to go forward unless anyone has any issues with that.
Okay. Again, thank you for the opportunity and just wanted to give a brief background on different forms of regulation, and I am glad to take questions following my presentation. And just wanted to note what occupational licensing is, and that is what workers do at work that is regulated by the government. And I wanted to present, since I'm an economist, wanted to present some of the costs and benefits of these regulations. First, occupational licensing has been a process that's been growing, especially following World War II. Right after World War II, about 5% of the workforce was regulated, and now that number is approaching 1 out of 4 workers are required to have permission from government in order to work. And the question that I'll be asking and providing at least some evidence, and be glad to take your questions, is does it add quality and efficiency for the people it serves? And also, how does licensing work? I want to provide a brief history of licensing. Following the Civil War, very few people were licensed. One can think of the famous movie The Wizard of Oz, where the great doctor, operating out of the back of his wagon, was selling all sorts of elixirs, and those were unregulated. And in fact, in the 1870s, maybe 1 out of 100 workers were regulated by the government. As a result of a couple of Supreme Court decisions, Dent versus West Virginia and Munn versus Illinois, occupational licensing was viewed as being appropriate for state governments to regulate. And you can see from about 1870 to right before the pandemic, there's been a significant growth, both in licensing, which is regulates tasks that workers can do, to certification, to registration. And what I plan to do is, again, go through the history of licensing. What are some of the causes of licensing? Why did it develop into the largest and most widespread type of regulation in the United States? So if you were to compare licensing to unions, licensing is more than twice as prevalent. Unions encompassing about 1 in 10 workers, and licensing about 1 in 4. What have been the likely effects on wages and employment? Does it have an impact on raising wages or reducing employment? And finally, what effect does it have on efficiency and quality? I thought I would take you to what I call licensing 101. And if I were to give you some of these issues in my class, these are the 3 types of regulation that are often used to distinguish different types of regulation. First, there's registration, which is it is unlawful to perform certain tasks without registering the government, but no competency requirements are set. Certification, which is a right to title, and it's unlawful to use modifiers such as licensed, certified, or registered without first obtaining a credential. And finally, licensing, which is a government credential and it's legally required to perform certain tasks. It attaches to an individual, that is, whether an individual has attained a license, and not necessarily whether they're covered by a license, and it requires some demonstration of competency. Can you do certain tasks? Can you pass an exam? Have you done and completed an internship or an apprenticeship? So those are sort of the definitions of licensing. Since the Civil War in about 1870, different types of occupations have been regulated. Following the U.S. Civil War management, in fact, the first couple of Supreme Court decisions involve tax collectors and whether they should be licensed. Over time, healthcare, including doctors and dentists, became licensed. Other services ranging from construction, such as plumbers and electricians and boilermakers, became licensed. So there's been a wide variety of occupations that require government permission in order to do certain tasks. And this has been an evolution in the US and many other nations. The states that are the first adopters of licensing are the larger states. So if you see that California has been tended to be among the first adopters of occupational licensing. If not the first one, was certainly among the top 5 and certainly among the top 10, with other states like Florida, New York, and Illinois also being among the first adopters of this form of regulation. Smaller states like Wyoming, Delaware, and Vermont have been among the last ones to adopt occupational licensing. What are the causes of licensing? One of the reasons is that the professions themselves tend to be movers toward occupational licensing. So if you look at whether a professional association, for example, dental hygienists or legal paralegals, form an association, and if you see an association being formed in a state, it is dramatically more likely that that association will lobby the legislature or the governor, and the outcome will be those associations will lobby the state, and an occupational license will be obtained by those by that association. And one can think of a wide variety, as I mentioned, physical therapists, occupational therapists, plumbers, electricians, interior designers, and more recently, genetic counselors have lobbied the states, and they have obtained an occupational license. Now, one of the questions is, what effect does it have? So given these are sort of what I would call the origins of occupational licensing, what effect does it have? Are there benefits, especially to the professions and the associations, of obtaining an occupational license? And there the answers are pretty much yes. That is, licensing has been shown to raise the wages of regulated workers, depending on the occupation, the time period, and the data used, somewhere between 4 to 15%. One of the reasons, or using some simple Econ 101, it reduces employment because you have to pass certain examinations, do apprenticeships, and do internships, and that reduces employment. It makes it more difficult to obtain a license. And it reduces employment compared to other occupations by between 25 and 30%. Also, prices tend to be somewhat higher. If you relax occupational licensing and allow, for example, nurse practitioners to provide certain simple services like well baby exams, it can reduce prices by about 10%. And the question is also, does licensing reduce labor market efficiency and equity? And generally, the results tend to be that they do. It reduces the ability to move across state lines. It reduces the ability to move across occupations. And it also tends to raise inequality because individuals in licensed occupations tend to get higher wages relative to those who are not protected by this form of regulation. Now, what effect is also, what effect does it have on different occupations? And here are a few case studies that I did in a recent book with a co-author, Maria Commenta, at the University of London, looking across different countries and different time periods, looking at various occupations like ride-sharing drivers like Uber, driving instructors, pharmacists in Italy, advocates, and in this case, our lawyers in Poland, where they dramatically reduced the requirements to be an advocate in Poland, and healthcare practitioners in the US, and makeup artists and shampooers. So generally, there has not been a big effect of licensing in terms of quality. There's no effect of quality for making introduction to driving instructors in the UK, or relatively little effects on whether certain cities have tougher or easier requirements for becoming an Uber driver. Similarly, makeup artists and shampooers who are licensed in some states and not in others, there was no effect on service quality measured by customer satisfaction. So generally, there hasn't been much of an effect or an empirical effect on quality for consumers of having tougher regulations. Given that's the case, why license? Well, a key public policy justification for occupational licensing is presumed to be the ability to protect the general public from either incompetent or unscrupulous practitioners. Going back to my Wizard of Oz analogy, the person selling the elixir out of the back of their wagon may be either incompetent or unscrupulous. Therefore, it's in the public interest to regulate those occupations. And that certainly was the case in the ruling in Dent versus West Virginia, giving states the authority to regulate occupations. Also, consumers often lack the knowledge to assess the quality of a product or service prior to purchasing it, particularly if it's technical or requires specialist knowledge or skills, and thereby setting a minimum qualification that an occupational license or regulation is expected to raise the average skill and competence levels in the occupation. So requiring certain levels of education and training increases the point of service to the consumer, especially since low quality providers will likely be unable to meet the new qualification requirements and therefore are driven out of the occupation reducing employment in these occupations. Finally, taken together in these case studies, they indicate that an increase in the availability of service providers doesn't have a negative effect on the quality of the service. And to the contrary, in a number of case studies, we find positive effects of increasing the availability and competition by reducing barriers to entry. So our overall conclusion is that licensing in occupational markets we studied serve more as grit rather than grease in driving and efficiency and quality. And this contrasts with the strong opposition that policymakers typically face from professional associations and licensing boards when trying to implement reforms. That is, you tend to get significant pushback from the occupations when there's an effort either to deregulate, for example, interior designers and or watchmakers have been deregulated. There tends to be some pushback from the associations to reduce regulation and really efforts to increase requirements or to become licensed by these professional associations. So those are sort of the overarching results of some of my research. Glad to give you a background, but I think it is better and I think more relevant to the work that you're doing if you can ask questions. So I've tried to leave sufficient time for you to ask questions. And I'm again delighted to provide at least some of these insights into to this group in terms of the dispute resolution certification program, and also have provided a number of studies which have focused on the role of occupational licensing and regulation across a wide variety of occupations and time periods and nations, so that those of you who want to do a deeper dive into this issue at least will have some places to go for that background. So again, delighted to take questions, and thank you for the opportunity to present some of my work to this group.
Professor Kleiner, I have a question if you're ready to take it now.
I'm delighted to do so. Thank you.
We are considering something that would require recertification every year. And again, we're talking about certification, not licensure in this group. I was struck by your mention of electricians and plumbers and my own background. When I got an adult teaching credential, it was for life. I never had to do any more qualification. When I had 4 licenses in construction many years ago, I was licensed by the state to wire houses or put in gas lines for houses that if I screwed up, it would kill somebody. But I never had to go back and get any recertification. Would you comment on the idea of requiring yearly recertification?
Whether it should be yearly, I'll leave up to this group. Certainly the ability to examine individuals and whether they're keeping up with the current status within an occupation is particularly important. And this is often done, for example, in the medical profession, that you may obtain a license for life as a physician, but if you're going to be a vascular surgeon, you need to be recertified by the organization that monitors and regulates vascular surgeons. So that may be a tactic that, and in terms of quality, it also allows the group to examine and to see what consumers of their services are finding. So if you're a dispute resolution expert, I think it is important to see if there have been complaints and what both parties or parties that have looked at this issue have found in terms of your ability to deliver high quality services.
Mr. DeBoe?
Well, I'm having a problem with certification because I find two conflicting issues. Now, we've been tasked with the requirement that we have tiers, TIERS. And I think if we have tiers, that means that if you're just entering the business, you'll be the lowest tier, and that's going to be, and they make it difficult for you to advance to the next tier if it's based on the number of matters you handle, because you may not get as many matters as a person in the highest tier. On the other hand, if we don't have tiers, all of us are certified, it'll be misleading. And the third problem I have, and it was raised by one of the members of the public, is if I'm a certified mediator or a certified arbitrator, I have areas of expertise. That's one of the advantages of arbitration, where you get an arbitrator who is skilled in a certain area, more skilled perhaps in the area that a judge might be. But if there's no way of parsing that out, a certified I can't arbitrate a patent case, let's say, but a person, unless he sees my curriculum vitae, is not going to know that. So how do you handle that?
Good question. And one of the issues is whether this really turns into a form of licensing. That is, only individuals who have certain requirements and have passed certain requirements to provide dispute resolution services can work? Or does this provide with certification that you can only say you are a certified dispute resolution expert, and then it is up to the parties to determine whether they choose you or someone else to resolve a dispute, to be an arbitrator and or a mediator. I've been on several mediation boards in a number of states, Kansas, Minnesota, and others, and generally that was by reviewing requirements or background. But the parties could choose a non-certified mediator or arbitrator to resolve their dispute. So it is really up to the parties to select whether someone is good at patent law, whether someone earlier might be appropriate to resolve a dispute in the construction industry. So it is really up to the parties to select someone who they think have particular expertise. Saying that someone is certified it would be much like saying someone has a particular educational background, a master's degree, a bachelor's degree, or in the case of labor arbitration, whether someone may have been active in the union and may have been a union steward or a union president to resolve those types of disputes. So it is really up to the parties, those who have, quote, skin in the game, to determine whether they want to select someone from the list that might be provided as a certified dispute resolution expert or someone else.
Well, I agree with that, Professor, but that isn't, under the present way we're operating, we don't need certification. because I am an arbitrator through the American Arbitration Association, and they'll see my and the parties who have skin in the game, they know my background because they see my CV. So what is gained by me being certified? That's the problem. That's what bothers me.
Well, first, it provides the parties with information on your level of expertise. And so you can be on the American Arbitration Association. Federal Mediation and Conciliation Service also provides lists. Each state, in terms of labor arbitration, provides a list. However, the parties can choose to go outside that list, and they can choose someone that they think has specific knowledge of their industry or their trade or their level of what they think might be appropriate for the dispute they're trying to have resolved. So this provides a background, like saying someone has a bachelor's degree, someone is an attorney. If that's what you think is appropriate, then you pick from the list. If you have expertise, if the parties themselves know of someone who might be particularly good in the industry, they can go outside the list. That's certification, where licensing says you can only choose from that list.
Thanks, Professor. I appreciate your doing this.
Dr. Getz.
Judge Bashan. Professor Kleiner, I really appreciate the distinctions you drew for us between registration, certification, and licensure, and particularly the fact that registration requires no competency requirements, whereas certification and licensing generally does. And, I just want to, obviously in preparation for this presentation, you and I had a chance to have a Zoom, pre-Zoom, and I asked you in general, in your judgment, looking over certification areas, the competency requirements that are generally part of a certification process. And I think I heard you say, but I'd love you to elaborate on this. Experience was one of them. Training would be another one that should usually in the competency requirements and certification. And then you also said if there's an opportunity for an internship or mentorship or something along those lines, those were basically the three legs that you found in your overview of certification statutes, which is what we're working with here. Is that fairly and accurately represent your feelings about certification?
I think it does, and really enjoyed our earlier conversation in preparing for our discussion today. Yes, I think that that listing those as important factors and being on the list, that is, are there internships? Have you worked as a mediator or as an arbitrator in the past? Is particularly important. What types of education, what type of real world experience? And I think during our earlier conversations, I mentioned in the case of labor management disputes would be someone who may have handled lots of labor management disputes as practitioners. So sort of having boots on the ground may compensate for education and other sorts of credentials for being someone who handles disputes.
Thank you.
Judge Lucky.
Doctor, thank you so much for your presentation. I had a couple of questions because within our group, different subgroups have had varying approaches to what the requirements would be for certification. The points of view are we should have relatively minimal requirements for certification, or we should have rather robust requirements for certification. based on your slides, it seems that your research has shown that licensure, et cetera, seems to have a minimal effect on quality. I don't believe that we have the ability to say, well, we're going to do away with that with our group since it's legislatively mandated. But I guess my question, that's a long preamble to this, and that is, for a counterpoint, is there research that seems to indicate that the opposite of what you're finding? Are there studies that have shown that more robust requirements, registration requirements, licensure requirements have positively affected the quality of service in different domains?
Well, again, very good question. And there have been areas where, for example, you want, if there's a lot at stake, you probably want lots of qualifications. And the obvious example, if you're going in for brain surgery, you want someone who has done a lot of these types of procedures. But if you're resolving small claims court disputes, you don't necessarily either want to pay extra, because ratcheting up the requirements also ratchets up the cost. And if you want this to be widely used by consumers, then you want to keep those requirements minimal. But perhaps, as you discussed earlier, if you have level 4 disputes where you have a lot on the line, you probably want to have individuals with lots of experience, training, internships, apprenticeships, and have done lots of these cases. So it really depends on what's at stake. And the variance would be from, again, the small claims court where $50 or $100 or $1,000 are at stake, versus multi-million dollars are at stake, where you would want someone with high levels of training experience and have been involved in lots of these cases with very good outcomes by the parties involved.
Thank you so much.
And Mr. Palevsky.
Hi, thank you. This may be outside the expertise, but aside from certification, licensure, and registration, I'm wondering if you have thoughts about the importance of ethical rules for professions, occupations, and whether any of your feedback here would be different in terms of quality, costs, and the effectiveness of having consensus or industry-wide or profession-wide ethical rules.
Again, excellent question. And this has been an issue that legislatures around the country have been dealing with. And let me give you an example that issues, should ex-offenders ever be licensed? So in the past, if you were an ex-offender of a felony or even misdemeanors, you were precluded from entering licensed occupations. Over the past several years, those requirements have been dropped, and only individuals who may have had heinous crimes are precluded from entering regulated or licensed occupations. Also, certainly in the professions from law to medicine, questions of ethics are an important criteria for whether someone can enter these occupations, and whether they should remain in those occupations. Individuals who are attorneys can be disbarred. Individuals who have committed felonies, even though they may be outside their area. Recently, I had someone contact me I know this isn't the data, but always anecdotes always are of interest. Someone who had been in a medical profession or been in a medical group had been a highly qualified physician, but handled the books for the physicians group and was found to have embezzled funds. He served his time, came back, and wanted to re-enter as a physician, arguing that his past crimes had not been as a physician, but rather as an accountant. And he was not allowed to re-enter even as a physician. And many states are now setting requirements. If you are an ex-offender and it has been X number of years, you can then re-enter as a regulated professional. So there's been a wide variety. I haven't answered your question directly, other than to say it's very complicated and different states are using different criteria for what might be called moral character, and using moral character as a criteria for entering and remaining in an occupation. And I would suggest to this group that they consider the ethical criteria, both the individual's past behavior and their behavior as being a dispute resolution professional.
Thank you. I don't see any other hands, so I'm going to turn it back to Dr. Getz to close out our session and acknowledge Professor Kleiner.
Place. Thank you, Professor Kleiner, and also the working group for some great questions. We really appreciate your insights and have benefited a lot from it. So thank you for your guidance, and we appreciate your time today. So
well, thank you very much for the opportunity to have some input into your very important work.
Thank you, Professor Kleiner. Let me second that. That was very informative and very enjoyable. Thank you for spending time with us. And Professor Kleiner, oh yes, you're working on taking down your share screen. Thank you. All right, we'll move on then to item 2.2, which is a report on the updated recommendations from the baseline certification for mediators subgroup. And this is an update since our last meeting on April 23, 2025. Ms. Curtis.
Yes, hello. I want to first of all thank my group for all of their hard work, the subgroup, and I'm going to present in two parts. This first part will just be to let you know the process that we've followed and the fact that we have reached consensus on requirements, baseline requirements for training and also for recertification, but we haven't reached consensus on experiential requirements, and I'll explain a little bit later, and then we'll give you details about what those are. So you'll remember that at our last meeting, we did have, we presented our recommendations at the time related to training of mediators, and based on your comments in particular, that the one sort of definition, if someone hadn't had any training but had been mediating and had mediated 25 or more mediations and then had done 5 mediations within the last 2 years. Some of you raised concerns that that might be too stringent. And then we also had comments from the staff that they were reserving their, they so far what we developed they seemed in agreement with, but they also wanted to see what we were going to do with experience and also recertification. So we went back to the drawing board revised our previous recommendations and reached consensus on the requirements for training by relaxing those requirements that you were concerned about, and then also completing our discussions about recertification and also the training requirement. I mean the experience requirements. So I think that's, just basically it, except to say that we had, we're very close to consensus. I think there was one person who didn't believe we should have requirements for experience in our group, but I'll present those later.
Thank you so much, Ms. Curtis. We do have the memo. I enjoyed reading it. Thank you to you and also to the members of your subgroup.
Thank you, Judge Bassan.
We'll move on now to item 2.3, and that's a report and baseline certification for arbitrators subgroup activity since April 23 of 25. And this is to be presented by Judge Jackson Lucky, and we did only allot 5 minutes, or what, if you need more than that, of course. And that's because we understand that there hasn't been a meeting since our last meeting on April 23. Judge Lucky?
If I use 5 minutes, then somebody should slap me. I sent out an email to my group, and again, I appreciate the hard work that my group has put in. Asked if we felt that whether we had consensus or whether we needed more meetings, and the group by and large said we're willing to meet and talk some more, but we do believe that we've reached consensus on what our recommendation is, and so we're submitting the recommendation that we had submitted previously. We felt that we'd reached consensus, and we respect that staff had differing opinions on what those requirements should be, but I think that after reaching out to the group to see if they wanted to meet again, there was willingness, but not really a feeling that we should move or change our recommendation at this time.
All right. Thank you so much, Judge Lucky, and thank you to your group for the work that has been done. So we'll move now to item 2.4, and that's a discussion and possible action on recommendation for general principles of State Bar ADR certification. So I'm going to ask Mr. Weiner or Ms. Doherty to present this.
Sure. I think that's, I think I'm designated to do that. Thanks, Judge Bashan, and certainly give Ms. Doherty the opportunity to correct or add to what I've said. So as the group is well aware, there were different views that were reached by the arbitrator and mediator subgroups about what the qualifications should be for baseline certification of arbitrators and mediators. And following those meetings, staff met with the chair, Judge Bashan, and vice chair, Dr. Getz, and had some conversations about how to grapple with that and how to present or represent the questions to the working group in a way that would make sense and that would lead to reasoned results, if you would. One of the conclusions that we reached was that it would perhaps be helpful to see if the working group can agree on some general principles for the ADR certification program, which would both guide decisions that are made by this working group, perhaps as soon as today, and on through its continued work, but that might also guide the State Bar Board of Trustees and State Bar staff and subsequent working groups as this project moves forward. So the idea was to propose some general principles to you for your consideration. These are principles that the chair and vice chair and staff have worked on, and that we're recommending for your consideration. and I think we hope approval. So Erica, do you want to add anything, Ms. Doherty, to that before we
No, I think you
dive
did
into
that well, Alan. Thank you.
Okay, thanks. So what I'm going to do, if I can, is share a screen with a couple of documents. Let's see if you can see what I want you to see. I'm hoping that you can see on my screen two documents, one Exhibit A on the top and one Principle 1 on the right-hand side. Can you see both documents?
Yes.
Great, thank you. So you have the memorandum that discusses, sort of lists each of these proposed general principles and provides a brief reason why the working group leadership and staff thought that these would be important. There are 7 of them, all told, at the current time. We recognize that there may be additional principles that the working group may want to consider today or as it moves forward. What we're suggesting as a process, if you will, is that I will briefly introduce each one of these 7 principles, and then there'll be an opportunity for Ms. Doherty and Judge Pichon and Dr. Getz, and then working group members to comment on each of them. We have a draft on the right side, Principle 1. There are draft resolutions, and there's one for each of these proposed proposed general principles. And so the thought is to discuss the principle and then to see whether there's a motion to adopt a resolution, either to adopt the principle as stated or perhaps to adopt it with revisions, and in which case, if there are revisions proposed, then I am prepared, I hope, to try and edit what we have on the right-hand screen real time. So with that said, the first general principle that leadership and staff thought would be beneficial is that there be consistency among the types of requirements for certification of different types of ADR providers. So we've been dealing with arbitrators and mediators up to this point, but we anticipate that there may be other kinds of ADR processes that may be addressed either by this working group down the road or by perhaps further working groups or staff in the future. And so the idea was that while the requirements wouldn't necessarily be identical and probably wouldn't be identical, the types of elements or criteria should perhaps be identical. So if training is required for certification of one type of practitioner, should it also be required for all other types of practitioners, even though the amount of training and the content of the training would certainly be different. And a couple of reasons why leadership and staff thought this would be beneficial, partly based on the consumer expectations. If a consumer understands that certification means that certain what are kind of known as personal qualifications, education, training, experience, be associated with the certification of one type of ADR practitioner, they might reasonably expect that similar personal qualifications would have been met by other types of practitioners. From an administrative standpoint, it also seems to offer some benefits, both in terms of a practitioner who may be applying for different types of certifications, say as an arbitrator and a mediator, and maybe as something else. And finally, there didn't really seem to be a strong or compelling reason, in our view, for having a requirement for one type of practitioner, or a criteria such as training or experience, but not for other types of criteria. So based on those considerations, the chairs and staff we're proposing the general principle that the requirements for certification of all types of ADR practitioners of different forms of ADR should contain the same elements or criteria for all forms of ADR for which certification is offered. So that's the resolution as we're proposing it. Ms. Doherty, do you want to add to that? And in that case, Judge Bashan, I think we turn it over to you and Dr. Getz and the working group members for discussion.
Thank you. Thank you very much, Mr. Weiner. Would anyone from the group like to comment on the first principle? Yeah, I don't see any hands.
Chair, I think, I don't know if you can see it. I think Mr. Yamshan's hand is raised.
Oh, okay. Mr. Yamshan.
Hi, thank you very much. When I read this last night, I can understand why it could be beneficial for absolute consistency across all types of ADR practice. But what will happen if we pass this resolution is either the hard work of the mediation subgroup or the hard work of the arbitration subgroup essentially would be nullified. And what it does not do is recognize that they're very different kinds of practices. They're both under the rubric of ADR, but arbitration and mediation are very, very different. So why I have to wonder why after one or both of the groups have worked so hard to reach consensus, why this would be important, because it essentially would nullify the work of one of the groups or the other.
Mr. Weiner, would you like to address that, or Ms. Doherty?
Well, I can speak to that just briefly. The intent is not to nullify the work of either group. And the hard work of the leaders of all of the subgroups and their members is greatly appreciated. As I think you all know or should know from the last meeting and from the memoranda, staff have a different view from the arbitration subgroup about whether there should be requirements for training and experience in order to become certified as an arbitrator. We also recognize that there are varied views among the working group members outside of the two subgroups that have reached different understandings of what would be beneficial to qualify. One of the questions that the leadership and staff have considered is whether, if this general principle were to be adopted, whether it would be appropriate for the arbitration subgroup to go back and look at it and come up with some recommendations for training and experience that would be appropriate and that would be consistent with the guidance of what the working group would be if it adopts this proposed principle. And again, we value, we would hope that we would like to have the input of and the expertise of the arbitration subgroup in coming up with recommendations for training and experience that would be considered appropriate by the folks with that expertise. We do feel strongly, though, that state bar certification of an arbitrator and a mediator and other kinds of practitioners should be indicative of some level of training and experience.
Okay, thank you. Ms. Doherty, Ms. Ellis had her hand up first, so
I'm happy to let Ms. Doherty go first. I had a separate and independent comment or question.
okay, all right, thank you, Ms. Doherty.
Yeah, I think all I want to say is just I agree with everything that Alan just said, but let me just say kind of procedurally how we were talking about this, and I think that was kind of raised already earlier. But I think this is kind of a starting point for conversation. As you probably saw in a that we think that this is something that would be very valuable for this group, as you've seen in the working group's charge. There has been a thought from the very early stages of this working group that there will need to be tweaks to this program as it following its initial implementation. And that could be many different things, including expanding to other ADR processes. It could be fine-tuning whatever requirements are ultimately adopted, so forth and so on. So what I think we're suggesting here from a very big picture perspective is that for future staff or future board members or a future working group, to the extent there might be one, that is going to be looking at this program, it could be helpful to have a general principles from which the working group formulated the specific requirements for each of these processes. So that's kind of where the genesis of this is. That being said, it's very possible, as we go through these, that the members of the working group don't agree with them. And so I think that that's kind of where we're hoping to, by going through these one by one, have a dialogue and discussion and conversation about, whether there is consensus around what you're currently seeing on your screen as it relates to item general principle 1 or something different from that.
All right, thank you, Ms. Doherty. Ms. Ellis?
I just wanted to note Business and Professions Code 6173 has some really curious language in it related to ethics standards. In particular, under 6173B2C, it states that levels or tiers will only reference standards of conduct described in, 1A or B, and those are the arbitrator and mediator ethics standards. So I just wanted to kind of seek clarification that the idea for principle 1, there might be kind of an exception for ethics standards, deciding or depending on what folks make of the language in 6173 B2C. So just wanted to throw that out there as a point of concern.
Okay. Ms. Ellis, are you stating with respect to the ethics criteria that there may be a difference between the two?
I think so. The way principle 1 is phrased, with the idea that each type of ADR practitioner, those requirements should contain the same elements or criteria. I am just trying to understand how we deal, like, say, if we're talking about other neutrals besides arbitrators or mediators, are we comfortable with this principle maybe carving out or accepting ethics requirements for those folks, depending on how we read this language?
Okay.
So I just wanted to get that clarification.
All right, Dr. Getz?
You, Judge Pashan. Alan, I'm wondering if you would look at 1 and 2 and clarify for us what 1 does that 2 doesn't do for you. In other words, I guess as people bring up different issues with approving number 1, I'm wondering if principle number 2 doesn't have everything you wanted in number 1. And there may be some clarification I'm not understanding. But if you could elaborate on what's the difference between 1 and 2, that would be great.
Sure. So I think Ms. Ellis raises a good point about the ethics requirements, as I understand that point, is that there are ethics requirements specified in section 6173 for mediators and arbitrators, but not for other kinds of practitioners. And therefore, if one included ethics requirements, for example, for mediators and arbitrators, how could that be consistent with the criteria for other types of practitioners for which ethics requirements are not specified in the statutes? Ms. Ellis, do I have that about right? What you're asking?
You
And
do. Thank you, Mr. Weiner.
thanks. And so what you're saying is, would it make sense to possibly amend this general principle to say, except that ethics requirements specified in 6173 would apply only to mediators and arbitrators, but not to other types of practitioners? Is that, just sort of the general sense of what you're asking about?
Or at least leave that possibility open, right? To have that difference in baseline criteria for,
Sure.
Great, thank you.
Yeah, so I have tried to capture that, and I'll try to capture other suggestions for edits as we go, as the discussion continues. And I think that perhaps leads well, Dr. Getz, to your question of what might be included in principle 1 that wouldn't be in principle 2. And so the question that Ms. Ellis raises about ethical requirements might be one. And so potentially what might happen if the working group decided to adopt principle 1, it may need to seek out ethical requirements for other kinds of practitioners for which they are not mentioned in section 6173, as Ms. Ellis points out. And how that would take place, I think is somewhat open for discussion. Whether the working group, if it decides, for instance, to develop a certification criteria for referees, whether those referees could be, whether the working group could specify ethical standards such as the standards of judicial conduct, which already address referees, for referees, or perhaps whether that might require a recommendation to the legislature that there be an amendment specifically authorizing or specifying ethical standards for referees or other types of practitioners. Dr. Getz, does that help at all?
It does help. Thank you.
Mr. Palevsky?
Following up on that, the statute does refer specifically to providers, and it does specifically refer in general to ethical rules. I noticed that none of these proposed principles seem to address providers in any way. It's always practitioners. And I don't know if that is left for a later discussion, or you're intending to exclude providers as an entity that we are supposed to be addressing, because obviously there's different issues with providers and practitioners. But it's really important, at least for me, to understand how ethics is going to fit in. Ethics is only mentioned in brief in one of these. And I think ethics across the board is really important and authorized by the statute. And I'm curious as to what your thoughts are about including providers in any of these principles, either the ones you've got here or some additional principles at the end of this discussion.
Sure. Judge Bashan, may I respond?
Oh, yes, I was going to ask you, I think that's a really good question, whether ethics is, well, when you use the word practitioner, I just assumed it meant everyone mentioned in the statute, but please go ahead.
Sure, thank you. So it was not intended to exclude or to be exclusive of the other types of ADR, if you will, entities that are referred to in the statute. At this point, the two subgroups, two of the three subgroups have been focusing on requirements for individual practitioners, be they arbitrators or mediators. And as I think has come up in in prior discussions around the working group and may come up later today. We haven't really yet had the wisdom of the working group on what the certification should look like for providers. And I would anticipate that when we, well, first of all, if the working group thinks that it's helpful to have general principles, such as are proposed here for practitioners, that when we explore certification requirements for providers, that we may well come up with some suggestions for general principles for providers. I agree that ethics are important and that ethics are included, specifically specified in the statute, and perhaps they should be more prominently addressed in these general principles, either by editing an existing one or two, or by adding an additional one or two specifically addressing ethical requirements. So just for example, there could be where 2 says should include levels of training and experience, perhaps could be added, and ethical requirements there, or there could be a separate 1.1 or 2.1 saying that ethical requirements, that all types of ADR practitioners who are for which certification is available should have ethical requirements.
Okay. Are there any other questions? Okay, I don't see
I
any.
see Mr. DeBow has his hand up.
Oh, okay, Mr. DeBow?
Following Cliff's idea, I think there need to be separate or different criteria for providers because they are different entities. For example, a lot of practitioners are independent, they're not corporations. And providers are corporations. Who owns the provider, for example? I recall we had a case in California, the name escapes me for the moment, where the arbitration agreement was from a provider which was owned by the party that drafted the arbitration agreement, and they appointed the arbitrators. So basically, the arbitrators were employees of the defendant. And, but how do you, so obviously, I guess the arbitrators might be required to reveal this under our criteria, but I don't, but how do you handle a corporation versus an independent practitioner? So I think we got to consider a separate standards or principles rather for providers.
Okay, thank you. And I see Mr. DeBow.
That was Mr. DeBow, who I think just spoke. I think his hand is down now.
Okay, all right. Those are all really good points. And as number 1 states, and as clarified by Mr. Weiner, it is related to practitioners. We haven't yet focused our discussions on firms and providers yet, and other types of ADR. So as Mr. Weiner said, we are focusing now on the practitioners, and it is for the types of criteria, not what they should be, just on the types. Like he said, they are, I lost my word. It would be the ethics. It would include, what were the other 2?
Training and experience.
Yeah, I'm sorry. The ethics, training, and experience should be included for all providers. So just those general elements. And I just want to make sure that you understand that there is no way that we would be invalidating any of the work, or that we would intend to have you believe that we're trying to invalidate any of the work of our subcommittees. We do appreciate the work and value it greatly. This is just direction from our entire group to the subgroups if they wish to consider them. So I'll go to Mr. Kelly.
Thank you, Madam Chair. I want to be sure I understood Mr. Weiner's comment that was sort of in the middle of all of the long stuff. Staff didn't agree with the ADR subgroup, but with the arbitration subgroup, saying we want to limit it to the 3 elements that are in the statute and required. We want them to go back and take another look at this. And what I think I understand is that if we all approve this, that's what we're doing. We're saying to the arbitration subgroup, go back and take a look at this, see if the staff isn't right. I'm personally in favor of number 2. I'd like to see training and experience included, so I'm not against that, but I want to be sure what I'm voting on. Did I misunderstand, Mr. Weiner? You can straighten me out if I did.
Sure. No, I think that's essentially correct, Mr. Kelly. I think if the working group sees fit to adopt Principle 1, then I think that will open for discussion. There'll be a vacuum, if you will. Well, let me put it this way. There would be several possibilities if the working group adopted Principle 1. One is that there is a staff recommendation for baseline certification of arbitrators. And if the working group saw fit, it could adopt or modify that staff suggestion. Another option, as I had mentioned earlier, was that the working group could ask the arbitration group to go back. Judge Lucky's, the members of the group that Judge Lucky is leading, to go back and reconsider in light of the working group's decision on general principle 2, if you will, or the subgroup, perhaps the members of the arbitration working group subgroup would not want to do that, and perhaps there would be an interest in having a new subgroup or new configuration of subgroup members do that. So I think that there's several options for how we might proceed if that principle is adopted. Does that answer your question, Mr. Kelly?
Yes, sir. Thank you.
Mr. DeBow.
During our practice session, I mentioned a personal thing that I will be getting a call, which
Oh, yeah, of course.
I've got that call, so
Okay.
I've got to sign off.
Oh,
Sorry
well,
about that. But
I told you at the beginning, I certainly understand.
Okay,
And
well, thank you very much.
okay,
Okay.
you're welcome. Thank you for letting us know.
Okay, bye.
Bye. Mr. Yamshan?
Thank you. Mr. Weiner, did I understand the last part of your statement that if it goes back to the arbitration subgroup and the arbitration subgroup believes that its position is correct, then a new subgroup or the subgroup could be reconfigured in order to come up with training and other requirements? I think that's what I heard, but I just want to clarify that.
Sure, Mr. Yamshan. I was trying to say that, I thought there would be a number of different options if this principle was adopted. Perhaps perhaps the staff recommendation might be accepted or modified, right here and, by the working group as a whole. I think the question could be asked of whether Judge Lucky and his subgroup members would like to make recommendations for training and experience requirements in light of this general principle if it is adopted. And, perhaps they wouldn't wish to do so, or perhaps other members of the working group might wish to participate in that discussion. I wasn't saying that it would be any one of those several options. I would simply that it could be any one of them, and probably others as well that I haven't just thought of.
Thank you. And thank you for that question, Mr. Yamshan. But I hope you understand that the leadership, by that I mean the chair and the vice chair and Ms. Doherty and Mr. Weiner, we would never reconstitute or set up a new subgroup just to come up with a different recommendation from the one that has already been established. So we would not be doing that.
I understand. Thank you. I was just, maybe it was the way the statement was phrased, but I had that concern about reconfiguration. But thank
Okay.
you.
Yes, no, we would not do that. We do respect the decisions of all three of our subgroups. So principle number one is out there, and we've had very good discussion. And it would be whether or not the same elements apply to all of the types of ADR practitioners. So, and we have the resolution that is before you. I will entertain a motion. Either way, it's up or down. Okay, now by your silence, I'm not sure what that means, that you're neutral on number one or you don't like number one.
Chair, might I suggest just kind of a general taking the temperature, so to speak, of if the working group agrees with this approach more generally. I think that could be helpful in determining whether or not to kind of exercise the time in going through each of the principles.
All right, I don't hear anything regarding number one, so I'm not sure what the temperature in the room is regarding it. There was discussion on number two, and it was favorable discussion. So if we pass number one, just for right now, would there be any more discussion on number two? Is there anyone who would like, can we put that one up on the screen, the resolution? Would there be a motion for a principle number two?
So moved.
Okay. All right, is there a second?
Second.
All right. Any discussion that we haven't already had? Should I ask Ms. Marla to call the?
Sorry, Judge Pishon, I was wondering if we could have a little bit further discussion on this one.
Oh, sure. Ms. Ellis, go ahead.
Thank you. Back in April, I believe on April 21, we received a memo from the Office of the General Counsel, and it had some answers to questions that we had all been grappling with. But one question that wasn't answered, at least as far as I could tell, was whether the types of qualifications we've been discussing, so training and experience day, could also be included in higher tiers of certification. And so that's a point that's been troubling me, and I want to make sure I understand whether by adopting, say, this principle, we're saying that we will only be including training and experience at the baseline level and won't be increasing them and upping the training and experience levels for higher tiers.
Mr. Weiner, would you like to address that?
I'm going to see whether Ms. Doherty would like to address that in the first instance.
Sorry, I had to find my unmute button. I apologize. So yes, what we had done, just for those who may not recall, so at the April 23rd meeting, we had asked for OGC to provide, our Office of General Counsel to provide some very quick advice, essentially, as it related to what was required for, or what could be included in the baseline requirements. Meaning we had had some conversations that seemed to suggest that the baseline requirements maybe should be limited or would be required to be limited to just the things that exist in the statute. So the ethical standards for arbitrators and for mediators, essentially having a complaint process and a remedies process. I'm probably missing something and attempting to recap what the statute says. So we received kind of that quick advice from our Office of General Counsel in preparation for the conversation at the April 23rd meeting. Subsequently, there are many other areas within the statute that I think are quite open to some ambiguity, face some ambiguity, and we've asked for them to kind of clarify those and provide some guidance to us. And one of those is what Ms. Ellis raised was the question of what assessment of quality basically means, and whether whatever as it relates to training and experience and the baseline requirements is the limit, meaning that we could not have tiers that address additional education experience or training experience or education, additional actual experience, meaning having done more mediations or done more qualifying arbitrations and so forth. What we've heard back from our Office of General Counsel, which we could certainly, provide for a subsequent meeting, is that what's in the tiers needs to be tied in some way, shape, or form to things that are objective criteria related to accountability and consumer protection. Now, to me, the question is, what does that actually mean? And I think that there is an argument to be made, and this is where we are exploring further, is does consumer protection mean having more training? Does it mean having more experience in a particular field? And that's something that we are still trying to kind of sort through with advice of counsel from our Office of General Counsel. And Alan, I think I'm missing something. I'm pulling up what we've received so far, but if you have anything else to chime in on, that'd be helpful.
Sure. I would just summarize my understanding of the guidance we've gotten is that the earlier guidance was that training and experience can be included in the baseline qualification requirements. And the newer guidance is that there may be limitations on doing that in the tiers. And that kind of gets to what Erica was saying about, is it tied? Can you say that more hours of training is tied to objectively tied to consumer protection or not? So we don't have the answer on that, but I think if I understand Ms. Ellis's question, it is if the group adopts Principle 2, would that preclude different levels of education or experience in the tiers? And I think my answer to that would be that Principle 2 is not intended to do that, but that might be precluded by an interpretation of the tiers provision in Section 6173.
Okay, yes, I think that is a very accurate response, Mr. Weiner, so thank you for that. Let's see, Mr. Pileski had his hand up first, and then Mr. Kelly.
First, I support 1 and 2 in concept, but number 2 specifically refers to these training experiences, for instance, not being an unreasonable barrier. I think that we should be far more specific, because my belief in those is really conditioned on them being accessible and affordable, and because that's really where the expense is. Some of these training things that goes on for hours or days can get very expensive. And I really think that if the State Bar is going to impose these, which I think is a good idea, that the State Bar needs to take a much more active role in guaranteeing that there are cost-effective and accessible ways that smaller practitioners especially can satisfy them.
Okay, thank you for that. Mr. Kelly.
Thank you. I wanted to answer Jenna's question, Ms. Ellis's question. I think the statute is crystal clear that we don't get to say 25 arbitrations for the lowest tier and then 50 for the next and then 100 for the next. There's a section in there that says the different levels or tiers have to meet all the following requirements. And C says the levels or tiers only reference standards of conduct described in subparagraph A or B. I don't see how there's a whole lot of room for wiggle in that one. So I think there's a clear answer to Ms. Ellis's question, and that's the basis of my vote. Thank you.
Okay, all right. Thank you.
May I
And-
respond to that, Judge Pashon?
Sure, Ms. Ellis.
I agree with Mr. Kelly's reading of the statute. I mean, my view has always been that it also applies to the baseline tier, which is also tier. But the reason that the Office of the General Counsel's memo I found it interesting was it referred to, it has this kind of little parenthetical in it that says the state bar cannot base tiers on subjective assessments of the quality of programs. And so I took that to mean that the state bar was essentially finding that so long as there wasn't a subjective assessment of quality, then things like, say, training and experience would be fair game at all levels. But what I'm hearing from Mr. Weiner and Ms. Doherty is that there's been additional communications with the Office of the General Counsel, and maybe that recommendation from them has gotten a little bit more nuanced. But I think the reason that this is something that I was curious about is because, if there is, according to OGC's assessment, an opportunity to build in, say, training and experience at the higher tiers, then, what should the lowest tier look like? And if we can't build it in, then I think it poses a different question. And so, for example, levels of training, the arbitration subgroup's recommendation was that there is training on ethics on an annual basis. And so that's easy. Experience, that's different from what the arbitration subgroup recommended. So another possibility might be to split up principle 2 into 2 separate votes, one on training and one on experience at the lowest level. But just another thought on that. Thank
All
you.
right, so thank you. And thank you for that, Ms. Ellis. I'm not sure that what we're trying to do now is related to the tiers. That's something we have not come to yet. And I'm wondering, Ms. Ellis, if we might be able to discuss this at the higher level just for the criteria, baseline criteria for arbitrators, mediators for now. And we're going to set up subgroups for the tiers. We just haven't gotten there yet. So your question and your concerns are very important. We just have not reached them, which is why I believe that you're receiving what you believe is probably not the clearest answer. I mean, Mr. Kelly, I know yours is crystal clear. However, we haven't discussed at all the tiers. And I wonder if you can be comfortable with that for now.
I understand your position, Judge Pashon. Thank you.
Okay. That was very tactful. Thank you. All right. Any other discussions on number 2?
Well, I have a question. What I think I heard was Ms. Ellis proposing a friendly amendment to basically split this resolution into a training portion and an experience portion. I may have misheard that, but
Yes. But I think, Ms. Doherty, your point about general buy-in for the idea of having general principles, I just wanted to share my view that I like the idea of general principles. I think that this hopefully will be helpful. And I do wonder if we should try to go back through the exercise of a motion beginning with principle 1.
Okay. All right. That's fair. Very fair.
And if you need a movement, I can, I'm happy to move.
I'm sorry, but there's a motion on the floor and the maker of that motion doesn't agree to withdraw it or to a friendly amendment at the time. It can be voted down if you want.
No,
Sorry,
no, no.
Mr. Kelly, I missed that.
No, that's
Go ahead.
perfectly fine. So we'll go, Ms. Ellis, we'll come back to principle number 1. Okay, and we'll take the motion that's on the floor. We do have a motion and a second. We have had discussion. And if there's nothing else to discuss, let me see if there are any hands. I don't see any
I
other
see
hand.
Dr. Getz's hand.
Oh, Dr. Getz.
I think hands, Judge Bashan, I think hands may be showing up more slowly on your screen than they are on mine. So if you don't mind, I'll let you know if I see one that you haven't recognized yet.
Okay, thank you. I'll defer to you. Dr. Getz?
Thank you, Judge Pashan. I just wanted to address number 2 just briefly.
Okay.
One of the things I admire about our field in general is our ability to take in new input. And I think what I like about number 2 is it's sort of the follow-up to Professor Kleiner's presentation and his material. And if you recall, I asked him that specifically about certification. On what basis does certification generally take place throughout the United States? And he did say training and experience. Now he also had a third element, which I'm not sure how we do in our fields, which is that sort of internship, mentorship. But he did definitely rely on training and experience. So I just wanted to again say that's why I support number 2, because it follows up on certainly the presentation and the information about certification generally in the United States.
All right, thank you. All right, so unless there is an objection from the group, based on the discussions we've had thus far, I'm going to ask Angela if you'll please take the roll.
Yes, may I ask who made the second to the motion? I did not catch that.
Dr. Getz.
Dr. Getz, thank you. All right, and we'll go ahead and take the roll. No, Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent, Dubois is absent, Ellis,
No.
Dr. Getz, Higuchi is absent, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopakin is absent, Cruz is absent, Lowe,
Yes.
Judge Lucky,
Yes.
Pulevsky, you're on mute.
Yes, I'm sorry.
Robertson,
No.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
No.
Judge Pichon.
Yes.
All right, so the yeses have the majority.
Thank you. So we will go back to number 1. And Ms. Ellis, I believe that you said that you may have a motion.
Sure, I would be happy. Actually, Mr. Weiner, would you mind scrolling up to the language for motion that the working group agrees with principle 1, accepting ethics requirements.
Is there a second? Let's see, Ms. Ellis, maybe it would be helpful if we take just a second. If you don't mind saying why you would like to exclude ethics, that is and I respect your motion very much. That is the one area that is mentioned in the statute that we are required to include. So could I just ask you to let us know why you would exclude ethics? And that might help
Thanks, Judge. I agree that they're required for arbitrators and mediators. It is difficult for me to understand what the statute requires for other types of neutrals, to be honest, in the way it's currently phrased.
Okay.
If the answer is that I don't have a second, perhaps we should just move to principle 3 and go
Okay.
down the line.
Okay, well, thank you for your motion. I'll again ask, is there a second? Okay. All right, well, and Ms. Wood, correct me if I'm wrong, the motion will die for lack of a second, or we just move on?
Yes,
Okay.
both.
Okay, so now we'll move to principle number 3.
Okay, thank you, Judge Bashan. So I think number 3, well, it reads the baseline requirements for certification of newer practitioners should require more training and less experience than that required for very experienced practitioners and should not constitute a significant barrier to certification of newer practitioners. The idea here, there were discussions, particularly in the mediation subgroup, I think maybe to a lesser extent in the arbitration subgroup, that there are practitioners who have a great deal of experience, but who may not have completed training. And to have somebody who's been practicing for 25 years, for example, as a mediator, go back and take a 40-hour basic mediation training, which is what's being proposed for newer practitioners, struck the that subgroup as a non-starter. So the idea behind this general principle was that there might be sort of a teeter-totter where for practitioners who have less experience, they should have more training, and vice versa for practitioners with much more experience. Another aspect or consideration that it lies behind this is that newer trainings practitioners who are trained more recently would receive a more current level of training, if you will. So if there are newer ethical standards that have been adopted in the last 5 years, those would likely be covered in a more recent training. They may not have been covered in less recent training. So those are sort of the considerations that were underlying proposed principle 3.
I'm sorry, could you put those up on the screen for us again?
I'm sorry, I thought that they were. What are you seeing? Do I need to reshare?
We're seeing principle 3.
They're visible.
Okay.
Mr. Kelly, you can't see it?
Yeah.
They're not appearing on my screen, so.
There's 2 tabs at the top. There's one that says Alan Wiener's screen. I don't know if you have that. You might need to click on that.
I don't have any tabs. Oh, thank you. I apologize. Now I have it. Thank you very much. Sorry.
Okay. All right. Ms. Jones.
Yes, thank you. I might be concerned about the word require. I think a lot of quote unquote new practitioner are individuals who've recently retired from the bench, who perhaps don't have like private mediation expertise, but also aren't going to go and take a 40-hour class, having just left like the settlement department or something. So maybe we could consider like as an option, the newer practitioners could have more training and less experience, like a sliding scale or something, just so that any individuals who are coming to us from the bench wouldn't be forced to take a course if they jump in right away, having just, sat in the settlement department for years and years and years.
Does that help with the word? Okay. Let's see. I didn't see whose hand was up first. So I'll just start at the top of the screen with Mr. Kelly.
I actually think that judges who've been doing settlement conferences, which are expressly excluded from the definition of mediation in the evidence code, should take a 40-hour training. I may be alone in that.
Okay. Ms. Hodgson.
I agree with the prior comment that, and I'd like to see this reflect more of the sliding scale approach, where we look at someone's entire experience and training, both because I think Mr. Wiener's point earlier was historic training may not have the most current ethical requirements or rules, but they may have significant experience. And I have found that when we overly attach training and the time within which the training has occurred, it can be a bit prohibitive to people who are interested in being certified or joining, in my circumstance, our court panel. Once we switch to more of a sliding scale, holistic view of what is your experience, what is your training overall that you are bringing to your credentials or your mediation or arbitration practice, that has led to a lot more success and a lot more interest in people being involved.
Thank you. Mr. Yamshan.
This may seem a little strange, but I would assume that training also includes presenting trainings, because somebody like Mr. Kelly, who has literally presented thousands of hours of training, should not need to take a 4-hour refresher, for example.
Thank you. I thought I saw that somewhere.
Yeah, I missed it.
No, I'm not seeing it in number 3, but
Sure, I
yeah.
think it's not in the general principles, but I think that concept has certainly been contemplated. I know it's been discussed, at least at the mediation subgroup level.
Okay. All right. Thank you. Let's see. That was Mr. Yamsham. So Mr. Pileski?
Hi, I like the idea of recognizing experience, but as to 3, 4, and 6, when it comes to arbitration, we really should discuss what it means to have experience. Because in my experience, most arbitrations go to an informal conference and never even get to a hearing. And that's where the real action is. So I'm not really sure how we define experience of arbitrations for the purposes of this principle, or even as we go forward with the standards.
Okay. All right. And Judge Lucky?
Thank you, Judge Prashant. This one concerns me a lot, and it's not for people who are in the retired judge position. I think a lot of us go to providers who give us mediation training for free that's not available to others. And then, I personally went to the Strauss Institute for training as well. I think what concerns me about this is what Ms. Hodgson said and what we got from Dr. Kleiner, and that is for the low, I don't like to use the word low stakes, but for the less complex, the more common, the people who might want to get a quicker resolution, and people who are willing to take less experienced mediators. And one example that I can think of, and Ms. Hodgson knows that we had a very successful program at our court, at the Riverside Superior Court, with civil harassment restraining orders, and our mediators were law students, and they had a tremendous settlement rate. And what I see with this kind of teeter-totter mechanism that we're creating is we're putting the largest burden on the people with the least experience, and they may be the perfect people. And again, this was a concern with the public comment that we got from Mr. Wesselink, and I think also Mr. Bloomfield, that in their domains, the the training requirements that we might put on new people are going to possibly put impediments to access to ADR for people who have lower stakes claims, lower value claims, and claims that maybe the less experienced people aren't willing to take on. And the less experienced people haven't had adequate training under whatever standard we set. And so this one troubles me quite a bit.
Okay, all right, thank you. Mr. Weiner, are there any other hands up?
So I'm not seeing any other than my own, Judge Bashan.
Go ahead.
And that was not a virtual hand. I just wanted to respond in part to Judge Lucky's comment. And that is, there are certain, well, I guess two things. First of all, the idea of having certifications for different types of cases is one that I've found attractive from the beginning, but I think it adds a dimension of complexity at this stage. As Ms. Doherty had said, there may be opportunities for enhancing and tweaking the program down the road. And frankly, that's something that I would particularly like to see. But my other thought is that this certification program is not going to preclude anyone from providing mediation, be it in small claims cases, civil harassment cases, or multi-million-dollar cases. As Professor Kleiner explained, certification doesn't preclude anybody from engaging in the practice. It only precludes them from saying that they're certified or that they've met the certification requirements. So I could well see if you have law students who are taking training in law school and ADR and mediation and arbitration as part of their law school curriculum, and they're mediating as part of a clinic, they may very well satisfy certification requirements out of the gate. But if they don't, they may well be able to satisfy certification requirements soon thereafter. And in the meanwhile, they wouldn't be prohibited from engaging in continuing to practice either in clinics or private paid cases. That said, I appreciate the concern, and I also appreciate the concerns that have been expressed about how to kind of balance training and experience. It's, I think, not a mathematical formula, and I think one of the ways that might be addressed in general principles is to reflect flexibility. And I'm not sure that adding the word generally does that. I'm sure there are better ways of doing that, and perhaps that can or cannot be done on the fly here.
I agree with you, Mr. Weiner. The discussion has been very robust and very extensive on this item. So I don't think it's possible to capture it in a resolution at this time. However, to keep things moving, I will just ask if there is a motion regarding principle number 3.
Judge
Move.
Bashan, if I may
Yes.
interrupt,
Go ahead.
I see Ms. Hodgson's hand as well as Mr. Kelly's hand.
Oh,
virtually.
okay. Ms. Hodgson?
I just wanted to respond to Mr. Weiner's points, which I think were very valid, and I think something for us to keep in mind that certification does not prohibit people from continuing to mediate or arbitrate or whatever sort of neutral they want to be. But I also want to respond by saying the whole reason that we're doing this, other than the legislative mandate, of course, is for it to be meaningful. And presumably, there may be circumstances or individuals, litigants, whomever, who say, I only want to work with someone who's certified. So in order for our certification process to be meaningful and impactful, I want to make sure that we are not inadvertently excluding people by being overly rigid in not being able to consider or be flexible about their history and their context. That's all.
Thank you. Absolutely. Mr. Kelly?
I'm in favor of this principle. I think there's some people who learn better in a classroom or training and other people who just learn better by doing it. And I think this is the right general principle. The more you've done it, the less you need training, and the less you've done it, the more you need training. So I'd like to make a motion to approve this principle as modified.
All right. Is there a second?
I second.
And that was Ms. Curtis?
Yes.
Ms. Marlad, would you please take the roll?
Yes. Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent, Dubois is absent, Ellis,
Yes.
Dr. Getz, Higuchi is absent, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopakin is absent, Cruz is absent, Lowe,
Yes.
Judge Lucky,
No.
Palevsky,
Yes.
thank you. Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan. Mr. Yamshan, you're on mute.
Yes,
Judge P.
because
thank
of the inclusion of the language generally.
Judge Pichon.
Yes.
The yeses have the majority.
Thank you, Ms. Marlad. I know you'd like to take a break, so I'm going to ask you if you want to keep going or if you want to take a break. Can I just see
Judge
nod?
Bashan,
Yes,
can I just make a suggestion here?
sure.
I think based on the robust discussion of number 3, I think the discussion of number 4, which is basically just a flip,
Okay.
saying more experience should require less training, might be an easy adoption, if you will, perhaps with the word generally, and then we could come back and with a new subject after the break if you're so inclined.
No, that's absolutely fine. I am sensitive to being called a taskmaster, so I just want to make sure I don't keep going when we need to take a break. But yes, let's move on to principle number 4. Mr. Weiner.
Oh, I'm sorry. Yes, I apologize. So as I said, this is really sort of the flip-flop side of the teeter-totter, if you'll excuse the analogy. And it basically says that very experienced practitioners should not require as much training as newer practitioners, but should still be required to have completed some training within the last 2 years. And the idea of that is that it be ethics or continuing education. There'll also be a recommendation of continuing education down the road. And I think on behalf of staff, and I hope on behalf of the chairs, I would propose that we start out with the friendly amendment of adding generally here as we did to the other as we did with principle 3. And I guess the only thing I would say that's really different from this and principle 3 is that it would include requirement that experienced practitioners have completed some recent training. And I see Mr. Kelly's hand.
Okay. All right, Mr. Kelly.
I'm going to vote against this one because we haven't really discussed whether that 2 years is a reasonable requirement. So if you're going to keep that in there, I'm against it.
Mr. Weiner, can you tell me if there are any hands that I don't see?
I do not see any other hands.
Is there, okay, I saw a hand.
Erica. In the interest of people who want to break and moving this along, Mr. Kelly, if we remove the within the past 2 years language,
Yes, I'd vote for it.
Okay.
How about recent training?
That works very well for me. We just haven't talked about whether 2 years is the right length of time, and I'd like to have a lengthier discussion than before everybody needs to go take a pee break.
If I can break in,
Yes, I can't see who's speaking.
That's
this
Mr.
is
Yamshon.
Okay. So
yeah, recent can be very ambiguous and be even shorter than 2 years. And so I'm wondering if it would be more artful to say during a time period to be determined or something to that effect.
okay. Is there any opposition to that language?
No, but I have my hand raised, and I just want to point out that I'm looking at the documents that were posted on the hub, and the language is slightly different for some of the principles than what's being put on the screen. And the language, it basically mirrors what Mr. Yamshon said. It says within a specified time period. I think that might be what we're looking for, but it does differ slightly.
Okay, thank you.
So I apologize for holding up everybody's break for what I thought might be a very simple
That is okay.
side.
That is fine. So as it's currently worded, is anyone willing to make a motion?
So moved.
That was Mr. Kelly.
Second.
Is that Dr. Getz?
Yes.
Okay.
I'll take the vote.
Mr. Weiner, do you see any other hands up for discussion?
I do not,
No,
Judge
okay.
Bashan.
Ms. Marlotte, would you please take the roll?
Armstrong? Armstrong?
Yes, sorry.
Coulter?
Yes.
Curtis?
Yes.
Dinkin is absent. Dubo is absent. Ellis?
Yes.
Dr. Getz? Higuchi is absent. Hodgson?
No.
Jones?
Yes.
Kelly?
Yes.
Kopaken is absent. Cruz is absent. Lowe?
Yes.
Judge Lucky?
Yes.
Polewski?
Yes.
Robertson?
Yes.
Tuckman?
Yes.
Welch?
Yes.
Yamshon?
Yes.
Judge Pichon?
Yes.
The yeses have the majority.
So yes, we'll take a break now. It's I'm showing 4:17. So how about, is 4:25 enough time for you? Okay. All right. So 4:25, we'll be back. So just go ahead and mute yourself, but please don't go away. On to principle. We'll move on to principle number 5. Mr. Weiner?
Apologies, I needed to find myself unmuted, and I'm sorry if there was a difference in the version of the principles that were being displayed before. What I'm now displaying is straight off the website. I'm not sure how they ended up different, but so proposed principle number 5 is that certified practitioners should be required to complete a specified amount of continuing education, including in ethics, that maintains or increases their knowledge and skills in each ADR process for which they're certified within a specified time frame to be eligible for recertification. So this talks about after initial certification, and it does uses the specified time language that was more favored in the previous. And the idea is simply that certified practitioners should stay on top of their game, if you will, on top of the latest learnings. And I think it probably speaks for itself.
All right, thank you.
And I see Ms. Hodgson's hand.
Yes, I do. Ms. Hodgkin.
Hi. One small, perhaps semantics. I heard Mr. Kelly's comments earlier about recertification during our presentation. And I think to a certain extent, at least linguistically, he makes an interesting point regarding the language of recertification. I wonder if recertification might be more aptly called ongoing certification. We're not, my understanding is the intention is not to have people kind of renew their entire application, but basically say, I have checked the boxes and I continue to check the boxes. So I would like my certification to continue. I think of it like my state bar licensure. I log on and I confirm that I have done the necessary training, I have paid my dues, I have done the things that I need to do, and I, thank God, do not have to take the state bar again. So that's my modification or suggested modification.
All right, Ms. Hudson, a change has been made. Does that suit with what you said, to be eligible, to remain certified?
I think that works.
Okay. And all right, I see Mr. Pileski's hand.
Question for the staff. Do you need the recertification for financial purposes to keep this program funded? That people who want to remain certified have to pony up something more than once?
I think that's an open question. I think it's very possible. So I think that it's depending upon the complaints process. I think that as you saw in the statute, the startup costs for this, if you will, are explicitly called out as something that could be higher, and then the cost to maintain certification could be lower. And so that's kind of already contemplated within the statute itself, and as well as what we're proposing. Once the once the shape of this exists a bit more, I think what we will be looking at is, from a staff perspective, is what it would cost to have this be a self-sustaining and self-funded program. But it's possible, and I think that really does tie to the, there's been a lot of conversations as the 2-year recertification, 1-year recertification. What should this look like? And I think that conversation is certainly in part, at least, tied to a funding mechanism for this.
And you can use the training if you actually get more involved in it as a source of funding.
I'm sorry?
You can use the training by sponsoring the programs or charging for the training.
Sure. That's certainly something that could exist to do an alternative way to essentially support the program.
I should ask, Ms. Doherty, are you comfortable with the remain certified substitution for recertification? Does that address what?
Yes, I think it's, I think that I recognize Ms. Hodgkin's point, and I think that this addresses it.
Thank you. And Judge Pichon, I see Mr. Kelly's hand raised.
Mr. Kelly.
Again, I fully support Ms. Hodgins' point, and I think it's a really good one to change the language. Thank you. Personally, I've actually taken more than 300 other practitioners' trainings and workshops, and I keep going to them all the time. I'm really in favor of continuing ed, but I've heard comments in the public programs I've done on this from people who are really worried about the cost, especially people who volunteer. The idea of having to pay for continuing ed over and over and over again is very bothersome and worries some people who are already donating their services, for instance, to the courts. And I want to raise that question. Some of them said, well, I hope the state bar is going to provide very low cost or free training to help us satisfy all these requirements. And I don't know if the bar has any intention of doing that, but I want to raise the cost implications of this.
Thank you. Are there any other hands?
I see no other hands, Judge Pichon.
Okay. Mr. Kelly, I'm not sure that can be incorporated in here, but your point is absolutely well taken. Is that going to affect your position or anyone else's position on this principle number 5?
I'm really in favor of continuing ed, but I would not be, I guess I'd have to abstain on this because we haven't figured out how volunteers are going to pay for continuing ed and whether there's any free availability of it. Depends on what we talk about with what we mean by continuing education.
All right, well,
You got to pay for it.
yes, Mr. Weiner?
Yes, Judge Bashan, thank you. I was just going to say to Mr. Kelly's point, perhaps that could be the subject of a new general principle to be adopted, that there should be cost-effective means or scholarships or something for appropriate people to be able to receive the training. And I would also repeat the mantra of nobody is required to be certified. And so we don't know what the costs of certification are going to end up being, but it would not prohibit anybody from practicing, from engaging in activities. We certainly want to make avenues for certification available, particularly to volunteers who have the qualifications. I don't think we would want it to be cost prohibitive, but as Judge Pashan said, I'm not sure how we can address it in this particular principle. And I saw Judge Lucky's hand.
Yes, Judge Lucky?
I'm sorry, I raised it and then I thought, but we do CLE as a matter of course if we're members of the state bar, and I realize that there may be some people who will be certified ADR professionals who aren't members of the state bar, but I think as long as it is affordable and is CLE that ostensibly we would normally take, we're just taking it in a slightly different specialty area. It seems like that's a reasonable thing for recertification.
Is there anything that we might insert in there just to say with consideration given to a cost and ability to pay, something like that, so that we can go ahead and vote on principle number 5? Mr. Pileski?
I like the idea of having a separate principle. I think this notion of having accessibility and affordability is so critical to everything that it deserves its own principle.
Okay, all right. Anyone else? All right, so if we indicate that we will entertain a new principle, maybe not today, because we need to make sure our wording is proper so that it can be passed our astute working group. Knowing that we think that that is extremely important, that we will come back to it. Are members of our group willing to vote on principle number 5?
Yes.
I heard a yes. I think that was Dr. Getz. Okay, I don't know. All right, so are there any other comments on principle number 5? Is someone willing to make a motion? Knowing that we will address the cost issue, because it is extremely important.
Lucky, I'll move.
Thank you. Is there a second?
Sarah,
I'll
I'll second.
Anyone else can.
I'm sorry. I didn't hear. Second?
This is Sarah, I'll second.
Oh, thank you. Ms. Marlott, would you take the roll?
Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent, Dubois is absent, Ellis,
Yes.
Dr. Getz. Dr. Getz, you're on mute.
Yes.
Higuchi is absent, Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopakin is absent, Cruz is absent, Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
Judge Pichon.
Yes.
It's unanimous in the yeses.
Thank you, Ms. Marlott. Principle number 6, Mr. Weiner.
Thank you, Judge Pashon. So principle number 6 is that all certified practitioners should be required to conduct a specified number of ADR processes for which they are certified within a specified time frame to be eligible for recertification. And this might be changed again to remain certified. I'll say that there was some robust discussion about the a requirement to continue to practice, if you will, in the mediation subgroup. The mediation subgroup, the members who were available to vote by email on the sort of final proposal did agree that there should be an ongoing experience requirement. From my perspective, I'll say that, part of the idea of the program is to certify practitioners. And if somebody is not continuing to be a practitioner, I question the value to them of remaining certified, although that's perhaps their decision, but also for the state bar to hold them out as a certified practitioner when they're not engaging in the practice causes me some concern. But I do note that there are, that this was a subject of robust discussion in the mediation subgroup.
Let's see if there are any hands.
I see several.
Okay, wait.
The first one I see is Ms. Lowe.
Lowe, yes.
Sure. So I have a few concerns and just some things for the group to consider here. One of the reasons behind the main statute, SB 940, I understand this is just one of the subsets, was a big concern over repeat players, arbitrators having a lot of cases with the same parties over and over and over again, and having something like a requirement where they have to have a certain amount of cases could almost further that. And I know there's a lot of concern with that. The other flip side to that is, I know we have a lot of neutrals who work on cases that are so unbelievably complex that take up almost their entirety of their time. Also, to prevent any conflict issues, they can't take on any more cases, and they're working diligently and full time on these matters, but they can't take something because they can go on for years. So removing their certification because they're dedicating time to a very specific matter for a specific amount of time sort of seems a little unfair, because they are basically their full-time practice, but it's just they're not taking on a certain number of cases. So I think those are just some things to think about when we're talking about that requirement. I think there's something to be said for quality over quantity. And then also the concept that we've talked about a lot is, what is a specific number? Is it an arbitration that goes to an award? Is it a mediation that went for more than 1 hour, right? Sometimes parties stop after an hour because they've decided they're not going to go anywhere. So how do we even get to that definition? I think that would be really, really burdensome and really difficult for practitioners to be able to remain certified if that's a requirement.
Good points. Thank you. Mr.
Ms. Lowe, if I could just ask Ms. Lowe, so I have proposed some language. I'm just wonder if we could see whether that would address Ms. Lowe's concern.
I think actively engaged, again, defining that could be very difficult, but I mean, I think it's something to consider. I think gets us a little better than specified numbers specifically.
Okay, Mr. Pileski.
Yeah, I think that this may be a little bit unnecessary. I mean, I love the concept of staying in the game, but small practitioners trying to compete with larger marketing organizations may not, despite their desire, have the ability to get as many cases. I don't know what the standards are going to be. And I also don't think there's any definition of arbitration. So I think it's a bit vague and ambiguous and maybe almost duplicative if someone's getting training and updated ethics and CLE. I'm not sure how important this one is.
Okay, thank you. Ms. Hobson.
I will start by saying that I like the amended language better, but I echo Ms. Lowe's concerns about some of the practicalities of this. I also want to just kind of have us be mindful as we move forward in this process and as we may explore defining this later on down the road, that life events happen and people are not necessarily able to practice or remain actively engaged in the way that they probably would have preferred. So being mindful of that, and just it's a slightly different context, but I'll share my experience with a court panel. We did for a time have a requirement that our panel members do a certain number of mediations per year, and that was not a successful endeavor for us. There was a number of obstacles for some of our mediators, both in terms of scheduling, in terms of geography, in terms of their expertise, that simply did not make appropriate cases eligible for their mediation, and they weren't able to satisfy our requirements. So we looked at it and we said, we're not going to do that anymore. So I want to be mindful of that as well as we move forward.
Thank you for your experience. Mr. Kelly?
When it's appropriate, I'd like to make a motion against this principle. I'd like to be able to take 2 or 3 years off, and it doesn't mean I forget the 20 or 30 years of experience I've had as a mediator and an arbitrator.
Okay, you want me to come? I'll take the other comments and I'll come back to you, Mr. Kelly. All right, Ms. Jones.
Thank you. I'd like to comment on the point of the ADR process for which they are certified, and bring up that, we've discussed mediation baseline certification and arbitration baseline certification, but we have not discussed the other areas of ADR certification. So without further defining what those processes would include, I think this principle might leave out so many of the other areas in which people practice. I think we just don't have enough information there yet.
Okay, thank you, Ms. Jones. Ms. Robertson.
Thanks. Yes, agree with Ms. Jones too. It's very different from area to area. We've discussed mediation, arbitration, but I agree other areas, I've worked with people in restorative justice and things. And so I do hesitate to be too restrictive for them. And I would also echo some of the comments about mediation. I could give myself as an example. I'm working as a professor and I'm supervising my students in like 3 to 4 mediations per week when I'm teaching during the semester, but I'm not doing very many on my own. And so, if that's the requirement, it might prevent me from being certified. And as someone supervising students in mediations, it's probably going to be important for me to be certified. So just to give, there are other examples. And so remain actively engaged, I think, is more in the right direction if we can have a broader definition of people who are conducting, things and using their skills and teaching and training that could capture the variety of ways in which people are working in mediation.
All right, thank you, Ms. Robertson. And Mr. Tuckman.
Yeah, I think that if we're talking about, a certification, I think if you're thinking about what the public is looking for, it'd be nice for them. If there is some actual number of cases that is associated with that credential that's being created, at the same time, I think that among the different processes that we have, the different types of caseloads that exist, it's going to be very, very challenging to come up with whatever number that is. I also, I think the concept of remaining actively engaged in the ADR process, the language that's been proposed as an amendment, I suppose, is okay. But I feel like it's going to be very difficult to come up with an actual standard for what actively engaged is for the different processes. My question is, given all that, whether what we're talking about here, because I think we are talking about, some people have used the word experience, seems like that's already accounted for in principle number 2, where we have language about baseline requirements, including levels of training and experience. Does that take care of it? Is that what we're getting at here? And if so, have we already approved a principle that it includes what we're trying to get at?
Okay, thank you, Mr. Tuckman. And Ms. Curtis.
Yes, I thought it might be helpful to give you sort of a preview of what the mediation subgroup came up with in this category of recertification. we said that there would be at least 4 qualifying mediations within the 2 years prior to applying for certification. So it was fairly long-term and not a very heavy requirement. And then we also added that there be at least 12 hours of mediation-related activity. And this captures some of the things that were mentioned, like you, Ms. Robertson, said, you know, you do a lot of teaching and training and observing and mentoring and that kind of thing. So, you know, and we defined that pretty broadly and gave some examples. So I'm thinking that it might be possible to kind of put those 2 categories together and come up with something where, and define actively engaged and have it be flexible enough, but still meaningful enough. Because I do think that keeping current in the practice in some fashion, teaching or mediating, is important to, you know, the ongoing abilities for people to kind of know that you're staying current and so forth.
Thank you, Ms. Curtis, for that explanation.
Judge Bashan, if I may.
Yes, Mr. Reno.
Thank you. So I appreciate all the comments that have been made, and they're certainly worthy of considering. I just want to add one kind of general idea about these general principles, and that is that the goal really here wasn't intended to sort of tie everything down in terms of what actively engaged means. But again, these are to guide the subgroups and to guide staff going forward and to kind of guide the state bar and future working groups. So having some generalness, if that's a word, to them is, you know, I think is beneficial, not to make them too specific. And you know, to Mr. Tuckman's point, not to, here in these general principles, tie it down to a specific number of cases, but let the mediation subgroup, you know, decide what they think would be reasonable requirements for remaining actively engaged. I think offers some benefits that aren't provided by being really specific in these principles.
Thank you, Mr. Weiner. Are there any other hands? All right, Mr. Kelly, you have a motion.
I move that the working group not adopt Principle 6.
Is there a second?
I'm sorry, I was mute. Daniel Yamshan seconds.
Okay. Ms. Marlott, would you take the roll?
Armstrong,
No.
Coulter,
No.
Curtis,
Yes.
Dinkin.
I'm sorry, I got mixed up. No.
No.
We need to clarify. A yes means you're agreeing with Mr. Kelly's motion.
Yeah, thank you.
Okay, all right, so let's do that again. Ms. Marlott, would you start again?
Yes. Armstrong,
No.
Coulter,
No.
Curtis,
No.
Dinkin is absent. Dubot is absent. Ellis,
Yes.
Dr. Getz. Dr. Getz, you're on mute.
Oh.
Higuchi is absent. Hodgson,
No.
Jones,
Abstain. I'm a little bit confused by this one.
Kelly,
Yes.
Opakin is absent. Cruz is absent. Lowe,
Yes.
Judge Lucky,
No.
Palevsky,
Yes, in its current form.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
No.
Yamshan,
Yes.
Judge Pichon.
No.
So we have 7 yeses and 8 nos. And 1 abstain.
Okay, thank you, Ms. Marlon. Does anyone have another motion to make? Okay, so I'm not sure how to read that, but if it sounds like no one wants to adopt number 6, but to vote to defeat adopting it, people have voted no to that. So
I think, Your Honor, if I may, I think under Robert's rules, if there's not a motion, the resolution dies.
oh yes, thank you very much. I'm just not sure if everyone was clear on the roll, but I'll have to accept what as it happened, and you're absolutely correct. So yes, there is no motion to adopt number 6. All right, so it will go the way of number 1, and we'll move on to number 7.
Thank you, Judge Pashan. So number 7 is something that's been touched on. Ms. Curtis mentioned it in talking about the mediation subcommittee's proposal. And that is that certified practitioners may receive partial credit towards experience requirements for recertification, or I would say for remaining certified, for engaging in specified activities that maintain or enhance knowledge and skills in the ADR processes for which they're certified. That really emanated, I think that general principle emanated from the discussions within the mediation subgroup, that there might be other activities such as teaching and mentoring and supervising students that might warrant credit towards whatever experiential requirements there may be for remaining certified.
Thank you.
And yes,
I'm sorry.
no, I think I should stop there.
Okay.
Thank you, though.
Well, I'll shortcut it and just ask if there's a motion regarding number 7, or are there comments first?
It's a question. How does this interact with what we just did or didn't do? If there's not going to be ongoing requirements, then getting credit for what?
Yeah, if I may share my thoughts, Judge Bishop. So I think that the number 6, the requirement that there be experiential or continued engagement in the process, the motion to reject that principle failed. There was no motion to adopt it. So my interpretation is at this time, there's not a general principle on whether there should or shouldn't be a requirement for experience. And the way that I would see number 7 fitting in is if a subgroup makes a recommendation that there should be an experience requirement, that would come to the working group as a recommendation from the subgroup. And if if 7 were to be adopted, there would be guidance from the working group that any experiential requirement could be satisfied by engaging in specified activities that maintain or enhance the skills in that process.
Does that answer the question?
Yeah.
Okay, great. Would anyone like to make a motion?
Ms. Ellis has her hand raised.
Oh, yes, Ms. Ellis?
Thank you. I just was curious about the partial credit portion of this. I think for partial credit that it might not address some of the concerns that we roundtabled for Principle 6.
Would your suggestion be to take out the word partial?
Yes.
Okay. Any other comments? I see a hand. Let me,
Mr. Yamshan.
oh, Mr.
Thank you.
Yamshan.
Yes, thank you. It seems to me that since we did not pass Principle 6, it kind of renders this one moot.
What if we did this?
Okay.
So if there were to be any experience requirements, this principle would say that other activities could be credited toward that.
Okay, I think that helps, Mr. Weiner. Thank you.
Okay. Any other comments? Is there a motion? All right, then, for number 7, there is no motion.
I was just going to say that I so move.
Oh, all right. Ms. Curtis has made the motion. Is there a second?
I'll second.
Right, who said that?
Chris Welch.
Oh, well, okay. Bob, would you please take the roll?
Yes. Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubose is absent. Ellis,
Yes.
Dr. Getz, Higuchi is absent. Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken is absent. Cruz is absent. Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Pichon.
Yes,
The motion carries.
thank you.
Chair, if I may,
Yes, just about to ask you, Ms.
okay, wonderful. I'm very mindful of the time and that we are losing working group members quite quickly. Alan, I don't know if you can see, I sent you a Zoom chat with draft language for a, I'm not sure what principle number it will ultimately be, considering we've not adopted a few of them, but we can call it Principle 8 perhaps for now, that you could put as a resolution on your Word document that attempts to capture the request to have affordable MCLE or reasonably costed MCLE or continuing education for ADR practitioners. Sorry to put you on the spot, Alan.
That's okay.
And I would suggest that it say reasonable because affordable can be very different for different individuals. That was an amendment to my draft language. It's in the last line, line 4. But I think this would be a starting point for the group.
I see Mr. Kelly's hand up.
When it's appropriate, I'd like to make a motion that we adopt that principle.
All right, I'll come back to you. Mr. Palevsky?
Thank you, Erica. I obviously support that. I think it should also say accessible, because if it only happens once a year, it's going to be hard to get certified. I just think it should happen at least on a time schedule so that it makes sense for people trying to get into the business.
Okay, thank you. Let's see.
All right, can I ask a question of Mr.
Sure.
Palevsky? By accessible can mean many things. Are you thinking you indicated frequency? I just want to make
That's
sure.
what I really mean. I mean,
Okay.
frequent enough so that it's something you can do more than once a year.
So periodic and reasonably cost or something of that nature.
Thank you so much. That's what I meant.
Did I hear my name Did I hear my name? Otherwise, I'll call on Mr. Yamshon and then Mr. Kelly. Okay, Mr. Yamshon, oh, you took your hand down? Mr. Kelly.
Well, I think Mr. Weiner is going to add in something about periodic or frequent or something. Is that right? We're not done with the motion yet, so.
Yeah, I'm changing this. Just my English teacher wants me to make it more of an active voice. I hope Miss Doherty doesn't mind. Resolve that the working group adopt a guiding principle that the state bar should offer required continuing education at reasonable cost, and it was with reasonable frequency, or
That sounds good to me, and I'm happy to make that motion.
I think you need, so now that we're wordsmithing, I think you need a that before, between principal and the.
Are you excluding training?
I'll speak to that. I think yes, at this time. I believe that in the arbitrator subgroup, Mr. Plesky, that you've been in, I think we have talked about the ability for the state bar to offer 30 hours of training in a self-funded program, and the costs of developing that, where I'm not sure that's something that could be accomplished depending upon what is determined to be the requirements for that training. So we have, you've voted on guiding principles today. I just, we could certainly explore this, but I think that's going to be something that would be hard to do. And that actually is a true statement here as well. I mean, I think we're working on an assumption that the continuing education would be relatively minimal. If it's not, and the working group ultimately decides that someone should be doing, 50 hours every year for continuing education to maintain their certification, I'm not sure we can offer that at a reasonable frequency and for a reasonable cost across the 50 hours. Maybe each one would be at a reasonable cost.
Thank you, Ms. Doherty. Mr. Yamshon?
Yeah, I don't think we should limit it to the state bar. And in terms of accessibility, there's no reason why county bar associations and community mediation centers and other providers couldn't provide the training as long as they meet the criteria.
I would say I would completely agree with that. I think what we're trying to say is that if we're going to require something in this space, that the state bar should offer it. I think this would not preclude other organizations from offering things. I don't think we can require county bar associations or other providers to offer affordable continuing education.
Yeah, that wasn't my intent.
Okay.
Basically, I didn't want the language to imply that it was limited to the state bar.
Sure.
All right. I don't see any other hands, and Mr. Weiner, Ms. Doherty have done a good job of trying to draft this resolution. So it is this second paragraph here.
So I think I flipped the order of my apologies, Judge Bashan. So I put some new language here, but I think that I'm not sure how we've resolved the question of county bar associations and others. I understand that Ms. Doherty's position was that the working group perhaps shouldn't, that county others than the state bar cannot be sort of bound, if you will, nor I suppose would the state bar be bound by the adoption of this principle. What if we say that, how about if we say the state bar, county bar associations and providers be encouraged to offer?
Or state bar should, Alan, you're on the same page as me. State bar should and encourage those other groups to do so.
Yeah, and there's no reason why private practitioners couldn't offer it either.
Private trainers, state bar should, and county bar associations, trainers, and providers should be encouraged.
Yeah, so, and then would be, sure, that works. And then I think you need a comma after your second
Yes.
offer.
Yes.
And Chair, I'll note the time and that Mr. Kelly has his hand raised.
All right, Mr. Kelly?
I'd like to go ahead and make that motion unless there's further discussion.
All right. Is there a second?
Second, Yamshon.
Thank you. Ms. Marlott, would you please take the roll?
Yes. Armstrong is absent. Coulter,
Yes.
Curtis,
Yes.
Dinkin is absent. Dubois is absent. Ellis,
Yes.
Dr. Getz, Higuchi is absent. Hodgson,
Yes.
Jones,
Yes.
Kelly,
Yes.
Kopaken is absent. Cruz is absent. Lowe,
Yes.
Judge Lucky,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
and Judge Pichon.
Yes.
Motion carries.
Thank you. I'm gonna just turn to Ms. Doherty now for her assistance with the remainder of the agenda.
Sure. So I think what will happen here is, given the time, it seems highly unlikely we will get through the other items on our agenda today. I will just note a few things. One is that I think that the chair, vice chair, and staff will get together and determine possible next steps as it relates to the existing subgroups based on what was voted to be adopted today as it relates to the guiding principles, if there's anything that the subgroups may want to continue to meet on. Separate and apart from that, the last scheduled meeting that this group has is in July. I do not know the date off the top of my head, but maybe Angela can gather that. So Angela will be circulating a meeting poll to get additional meeting dates starting after July, essentially. So you can look for those two things to be coming your way between this meeting and our next in July.
Thank you, Ms. Doherty, and to all of you, I just want to say thank you for a really wonderful discussion today. Your total involvement and commitment is truly inspirational. And with these principles, we've given ourselves a clear foundation to support our group's future. And as you know, what we develop as guiding principles will be used from. We are the inaugural group. We are the first. And so after us, many will come who will probably revise and modify and improve what we've done. But we are now giving them guiding principles to direct them and to let them know what it is that we expect from the work group regarding the Senate Bill 940 and the statute 6173. So I know you know how important our work is and how you each have contributed in such a wonderful way. Each of you have been selected for your knowledge and expertise and skill. It's been and will continue to be a pleasure and an honor to work with you. And I'm truly grateful for the work that you put in today. This has been outstanding. Thank you very much. So I don't need a motion to adjourn, but I can't be more grateful for all that you all have done today. So thank you very much. And you are adjourned.
Thank you.
Thank you for your work as chair, Judge.
Oh, thank you so much.
Oh, next meeting is July 16th.
Thank you, July 16th.
You're
All right,
welcome.
bye. Bye, everyone.